Good afternoon and welcome to the Senate Judiciary Committee hearings dated March 22nd, 2022. We're going to open the day by opening the public hearing on House Bill 1011 FN. Is there a House member to introduce the bill? Okay, seeing none, I will go ahead and introduce the bill. For the record, my name is Sharon Carson. I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I have for your consideration this afternoon, House Bill 1011 FN, relative to the penalty for criminal mischief. This bill increases the penalty for criminal mischief for destruction or vandalism of public property. Okay, the first person we're going to call is Terry Pfaff. Good afternoon, Mr. Pfaff.
Good afternoon, Madam Chairman, members of the committee. For the record, my name is Terry Pfaff. I'm the Chief Operating Officer for the General Court of New Hampshire, and I'm here in support of this change to the criminal mischief statute. By way of history, this was written in collaboration with the Attorney General's office a few years back, made it through the process and established it as a violation. The original draft from the AG at the time was a misdemeanor. It got downgraded in the process. We're looking to make sure that it goes back up because you can go down from a misdemeanor, but you can't go up from a violation. And what stimulated this was a lot of vandalism and defacement on the State House Plaza and others at the time. Okay. So we looked at, we really didn't have any teeth to do anything about it at the time. So that's why it went into the legislative process to increase the penalties. And again, it was done in collaboration in conjunction with the Attorney General's office. So looking forward to encouraging you to consider it, and please look upon it favorably. Thank you, Madam Chairman.
Thank you very much, Mr. Pfaff. Are there any questions from the committee? Senator Gannon.
Just remind me what the penalties are for a Class A misdemeanor.
I don't know those off the top
Senator,
of my head.
I believe we have the AG's office here, and we can ask them to come up and
Sounds
answer that
good.
question.
Thank you.
Okay. Are there any further questions for Mr. Pfaff? Okay, seeing none, thank you very much.
Thank you, Madam Chairman.
The chair will call Mr. Broadhead. Good afternoon, Mr. Broadhead.
Good afternoon, Madam Chair and members of the committee. I'm looking up the answer right now, but it's generally for misdemeanor A. So let's see. You can get. Let's see. So the answer is in RSA 651-2, and so a Class A misdemeanor is punishable by a fine of up to $2,000, $1,200 for a Class B. That's the difference there. There's an enhanced penalty for anybody that's a corporation. I don't think that would apply here. And then the terms of sentence. I don't know off the top of my head what the sentence is. I believe so. It's less than 5 years though.
Okay. Thank you.
Can I ask you one more question?
Yes.
Thank you, Madam Chair. Senator Cotton brought up an interesting point, as he always does last time. It was on a different bill, but it was to do with if you have repetitions over and over, the same occurrence, in increasing the penalty. Would that be already sort of written in here because they have a broad discretion to penalize lesser amounts and you could just raise it as you're going?
Correct.
So you're leaving the court discretion. Okay.
That's correct.
Thank you.
Courts have discretion. And
Thank you.
Senator Khan.
Thank you, Madam Chair. I noted the fiscal note, and whether this is an appropriate question for you or not, but hopefully in one of these bills that we're hearing today, the note is there several times that the public defender program has had the closed intake of new cases. Is that anything that you are familiar with, or no?
No, Senator. I think that I'm not familiar. I know that our office doesn't oversee the public defender's office. I think the funding source is actually through the courts, but I defer to Richard Head if he's here.
Yep, I saw him earlier,
Okay.
so. Well, hopefully he's signed in on something.
Nope.
Or if not, maybe he would, so that we could inquire about that's in the fiscal note.
Well, Senator, I'd like to point out this does have a fiscal note on it. So if we should pass the policy, it would go to finance and they would ask those kinds of questions. And I know, Senator, you used to serve on finance.
Which means I should know also how it's funded, but that aside, it's still, I think, something of a policy issue for us yeah, I mean, if we're unable to accommodate defense for people charged with, punishable offenses, then I think we've got an issue that somewhere along the way we would try to address in the policy. But not on this bill, because this is a necessary bill. Yeah.
Are there any further questions? Senator French, you look like you're pondering a question while Mr. Broadhead from the AG's office is here.
I was just thinking we saw this last year.
I think we saw part of it last year.
Yeah, my other question is, thank you. Does a Class A misdemeanor carry 1 to 2 years in prison?
It's less than 5 years. I don't know the exact answer to that. I know that it's somewhere buried in RSA 651A, 651-2, but I don't know off the top of my head. I'm sorry.
Okay. Are there any further questions? Seeing none, thank you very much.
Thank you.
Are there any other members of the public that would like to speak to House Bill 1011? Okay, seeing none, we'll close the public hearing. The committee will be in recess for 5 minutes. That's okay. Yeah, unfortunately, I didn't get a chance to look at it. You don't have any notes. Yeah. So, okay. Are you going to speak to?
Yes, I was going to speak to that. Right. Do you think it's germane? We'd like to discuss. Yeah. Thank you.
And they have come forward sometimes for additional allocations. I serve on the Judicial Council as the legislator. They have said that, but there are times when there's complex cases and they do training in experts. And so they will make a request to the fiscal committee for additional funds. So maybe they will do money in the so it would be interesting to see sort of update.
Sorry, no one by accident took all the sign-in sheets for 1333, did they? Someone, our sign-in sheets are missing now for 1333. All.
Look for Mark.
I didn't. No.
That's really interesting.
Yeah. Jenny, what I could do is just ask people who are to speak. That's all.
I just don't know where they could have possibly gone.
Okay, so, just let me know when you're ready.
Just gonna write people's names down as we go then.
Before we get started, before we come out of recess, I would like to remind the committee members that we are streaming, so please turn your microphones on when you are speaking. Okay, the committee will come out of recess, and we're going to open the public hearing on House Bill 1333. I see Representative Abbas is not here, but I do see Representative Welsh from the Criminal Justice Committee. Would you like to come forward and introduce the bill, Representative?
Yes, I can do that.
It's okay.
This is House Bill 1333.
Yes, please identify yourself.
All right. For the record, I'm Representative David A. Welch. I serve on the Criminal Justice Committee, and I'm introducing House Bill 1333.
Okay,
I have little to say.
that's fine. You've just introduced the bill to the committee. Thank you very much, Representative. We
Thank you.
appreciate that.
Nice job. Good job, Dave.
Okay, the signing sheet has disappeared. We are talking about 1333 FN relative to previous convictions for driving while intoxicated. This bill specifies penalties for a third or subsequent offense for driving or operating under the influence of drugs or liquor which occur within a 20-year period. Who here would like to speak to the bill? Please raise your hand. Okay, we're going to start with Mr. Broadhead from the AG's department, and then, sir, we will go to you, and then we'll go to Mr. Casco, and then we'll go to you.
Thank you, Madam Chair. Thank you, members of the committee. My name, for the record, is Matthew Broadhead. I'm a Senior Assistant Attorney General for the state of New Hampshire. I'm here on behalf of Attorney General John Formella, and here with me today is Assistant Attorney General Emily Gehring and Assistant Attorney General Benjamin Mackey as well. We are supporting HB 1333. It's laudable in that it increases the look-back period for the third and fourth DUI offenses to 20 years. But we were really here today to primarily inform this committee of recent developments in the law. There was a Supreme Court case last week in which we would propose that this committee consider an amendment to the law in the definition of way, which we think would be germane to this bill. By way of background, as this committee already knows, but there's two avenues to enforce the DUI law. It's one through criminal charges, and a second that the legislature created through an administrative license suspension process. And this second avenue was created by the legislature to promote public safety by quickly and efficiently removing unsafe drivers from the highway. Just last week, a divided New Hampshire Supreme Court held that the definition of the term way is different in the administrative license context, that it's more narrow than it is with respect to criminal conduct. And our office strongly disagrees with this decision. The court in that case, which is Rutter v. DMV, this dichotomy and this difference that was based on the legislative history never intended by this legislature. And to speak plainly, it creates an enforcement nightmare for the executive branch and local municipalities trying to enforce drinking and driving laws. So by way of kind of explaining, there was an enterprising attorney who took this reading of the statute to the Supreme Court and really found what amounts to a loophole in the statute. So what I have is a proposal to eliminate that loophole, to create consistency. Right now, the scheme that the Supreme Court has set up has held that the definition of way applies to 4 pinpointed statutes and doesn't apply to examples such as ALS suspensions, doesn't apply to administration license suspensions for commercial motor vehicles, which is a problem with respect to federal law. So what we would propose, and with the chair's permission, I'd like to circulate just an idea for discussion. Obviously, it's up to the committee to determine whether it's germane or whether you want to move forward with it, but what I wanted to do is raise this serious and important issue. We've consulted with the Chiefs of Police Association. They support this change. I've consulted with the Representative Abbas, who agrees to have this be brought forward on his bill, which he's the prime sponsor of HB 1333. And so with the chair's permission, I'd like to circulate that language.
Yes, please. I would like to inform the committee, received an email this morning from Mr. Broadhead with the intent of downloading it and making it available to the committee, but then the legislature lost its internet connection and we couldn't do that. Senator, it's beyond me. I don't know how this has happened, but you now will have a copy. Along with that email from Mr. Broadhead was a copy of the Supreme Court decision. It's Rutter versus the Director of New Hampshire Division of Motor Vehicles. It was argued September 28th, 2021, and the opinion was issued on March 16th, 2022. So just as soon as our internet is back up, we will make sure everyone gets a copy of that case so they can read it. So, Mr. Broadhead, would you walk us through the proposed amendment?
Absolutely. And just to be clear, this just amends the definition of the way. It does not although the facts of the case apply to, so-called, somebody that might sleep it off in terms of, I know that there's other bills that have addressed that. This doesn't affect that. What this does is it makes sure that those special rules that the legislature has set up for governing ALS and the criminal code, make sure that they're perfectly aligned. And that the conduct that leads to an ALS would also lead to, in a particular location, would also lead to a potential criminal component. What this proposal would do, it would add a section to the current bill. So it would be an entirely new section, and it would amend New Hampshire RSA 259-125, paragraph 2, to delete the 2 pinpoint sites and apply the definition to the entire chapter, 265A. The kind of highlighting the absurd result of the New Hampshire Supreme Court's decision, chapter 259 is the definitional section for the entire motor vehicle code. It's for the entire title 21. And so that's why these terms that are used in this particular chapter, 259, are applied in all other, in some circumstances, in other chapters that are within the title. Usually definitional sections apply within a chapter, and they go chapter by chapter. The motor vehicle code, just to create consistency, then the legislature's done this, is to apply them to the entire title. This really would, at the end of the day, if the legislature adopted this change that I'm proposing here, it would enforce the status quo. Law enforcement officers, thousands, hundreds in the state, have been trained to enforce the DUI statutes in a certain way, and what the Supreme Court had done last week is upends that and jeopardizes at least administrative license suspensions in particular areas. So we think that this, moving swiftly on this is important to create less confusion in the law enforcement community and to uphold what was, we believe, the original intent of the legislature, to make sure that conduct that could be criminally charged in a particular area could also be subject to an administrative license suspension for that same conduct.
Okay, thank you.
With that, I'll take any questions I can. I do have members of the Department of Safety who are with me here today. The Chiefs Association, I believe, is sending somebody or has sent somebody to support as well. With that, I'll take any questions that I can answer. To the extent that I can't, I'll try to defer you to somebody at Safety that can.
Thank you very much for your testimony. I have a quick question. I'm looking at the proposed language, and on the third line, second and third, well, really on the third line, it says any private way laid out under the under authority of statute. So if you have a private road that you maintain, if you're sitting there on your private road in your car quietly, maybe you want to have a beer or you want to have an alcoholic beverage, they can still arrest you?
My understanding is no, but I will defer that question, I think, to Chris Casco, who's here from the hearings, and Chris Storm, who's a member of the state police. And I believe the answer is no because of case law that is developed under that section, but I defer that to them on that specific.
Okay. Are there other questions? What about a religious parking lot, a church's parking lot? You're just pulled into the church and you realize I've just had too much to drink, I'm just going to sit here and I'm going to wait it out. Would someone be arrested?
Potentially. Now, the facts of the case in Rudder are this, that a person who, it was a known fishing location for members of the public to go and park their cars at. And this particular person was drinking in plain sight. The idea being, and the policy behind that, is that in any second, that person can enter the highway. And so generally any space that's open to the public, where the public is invited as a matter of policy, of course it's up to the legislature to decide that, and that's that's great. But I think from the law enforcement community, from a public protection perspective, we think that those definitions should include those public spaces that are open to anyone.
Okay, and just another question here, and it's me putting on my historian hat. People used to go to churches to ask for sanctuary protection for whatever reason. Would this violate? I mean, I see that there could be some tension between religion and the law. And I don't know how you could get around that, where someone could say, I'm claiming sanctuary in the church parking lot. You can't touch me. How would the state deal with that? How would they be able to supersede this?
That's an interesting question, and not one that I have looked into in terms of constitutional rights to, assembly at a religious facility. My gut reaction is that it would be an appropriate regulation of police power. Churches sometimes serve as centers for recovery centers and addiction centers, and so for somebody to be in a position, who's regressed in their treatment and shows up, they still pose the same danger to the public.
Correct.
So my sense is that would be a valid regulation of using the state's police policy. Of course, as a matter of policy, the legislature could see fit to change that.
Okay, thank you. Are there any additional questions? Mr. Lehman, you're kind of looking.
Well, there was an interesting sort of case that this Supreme Court decided a year and a half ago, having to do with religious liberty, that said state regulation has to be reviewed under the strictest scrutiny. So I think it would probably depend on the circumstances of each individual case.
Mm-hmm. Okay. Are there any further questions? Okay. Seeing none, thank you very much, Mr. Brennan.
Thank you.
The chair will call Chris Casco.
Good afternoon. Thank you, Madam Chair. With the chair's permission, I would ask that Sergeant Chris Storm, to expedite our presentation, be allowed to come to the table at the same time.
Sure, that's fine. Just make sure that before each of you speak that you identify yourself for the record. That's important because, yes, and spelling your last names, because we don't have the sign-in sheet, and it will make it easier for Ms. Horgan to make sure the record is accurate.
Yes, thank you, Senator. My name is Christopher Casco. The last name is spelled C-A-S-K-O. I'm the administrator of the Bureau of Hearings and Prosecution for the New Hampshire Department of Safety.
And I'm Sergeant Christopher Storm with the New Hampshire State Police, and I'm the state's field sobriety coordinator.
Your name is S-T-O-R-M?
S-T-O-R-M, yes.
Okay, great, thank you.
Madam
Did you get that, Jenny? Okay.
We appear today in front of the committee in support of House Bill 1333. We're here primarily to speak on the amendment addressing the definition of way, although we're happy to answer questions on anything within the bill generally. And interestingly enough, I was the hearings examiner in the Diana Rudder matter, so I'm pretty familiar with the hearing and what my decision was in the definition of way and how we dealt with it. But Senator Carson, I'd like to begin by answering one of your questions about someone who's seeking sanctuary in a church parking lot, and would they be able to do that? And if we changed the definition of way to be broader to include that, maybe that would not be a good thing. But I think this committee has addressed that to a large degree with Senator French's bill that became law, changing the definition of drive or attempt to drive or actual physical control that now exists in RSA 265A1 definitions, paragraph 6, which now defines drive, attempt to drive, or actual physical control, and says it shall not include sleeping, resting, or sheltering in place in a vehicle parked in any place where parking is permitted, provided that the person is not seated at the controls of the vehicle. And this law really is the culmination of work surrounding the issue of someone who's trying to do the right thing. And now the person trying to do the right thing has a legal mechanism to very easily do that. And certainly in the Rudder case, if she had been in the back seat or the passenger seat, then I think there would be a different result. We probably would not be here. Probably there would not have even been an arrest in that case. So I think the law adequately addresses that issue while correcting a deficiency in the definition of way as it exists, so that an administrative license suspension will be included as a way for purposes of DUI, the criminal charge in law enforcement. And one reason primarily is what happened with the Rudder decision now for a law enforcement officer, I think, is it creates confusion for the officer who finds someone impaired behind the wheel of a running vehicle in a church parking lot and not quite knowing what to do, because even though the Supreme Court says that person can be found guilty of DUI, they don't come under the umbrella of the administrative license suspension hearing if they test over or refuse. And the reason for that is the officer, after making that arrest, reads the ALS form. Our form number is a DSMV 426 is the number of that form, and it's required after a DUI arrest if the officer seeks a chemical test. They're required to read that form. Within the mandatory lines of that form, they have to tell a person that if they refuse or test over, their license shall be suspended. Now, under the Supreme Court case of Rudder, if it's a church parking lot, then that reading of the form is not necessarily shall, because the administrative license suspension process will no longer apply to that person. So my first thought of that for these cases was the officer simply does not send the form to the Department of Motor Vehicles to initiate a license suspension, although that goes against every other case that trooper or officer will handle in every other public way definition in current law. So this proposed amendment will clear up that confusion that this case decision potentially introduces. And the Supreme Court did, within the opinion, suggest that if the legislature intends to have the same definition apply to ALS hearings as a DWI criminal case, then the legislature is free to change the law and do that. We suggest that that would be the better policy. Kind of my thought process when I decided the case was that it does not make sense to separate out ALS definition of way from DWI criminal case definition of way. In fact, in the dissent, the justice suggests that within the scope of the ALS hearing, it uses the term, it doesn't say way, it says ways, which should include multiple definitions of way and not just the definition under 259-125 paragraph 1, that both definitions are ways. Therefore, when a hearings examiner is deciding a case, any definition of ways in law applies. So this amendment will clear that up, because clearly there is a difference of opinion. And many years ago, I decided a similar case. It involved driving in a private trailer park, and I looked at the definition of way in RSA 259-125, and I only applied paragraph 1. I did a narrow application. That was pre the Lathrop case, which is also cited within Rudder, and Lathrop, I suggest, expands the definition of way for public safety reasons. There's language in the Lathrop case that says there should not be any DWI-free zones, and that any roadway, even if it's a private road, Lathrop involved a private housing development, private roadway, but that any member of the public could drive into because there were no bars or gates preventing entry. The Supreme Court looked at that and decided, because it's open to anyone in the public to drive into, it should be a public way for purposes of a DWI case. And granted, Lathrop was a DWI case, not An ALS hearing, like the Rudder case, involves only the question of what was the definition of way for an ALS hearing, but certainly the language of Lathrop and the spirit of it. And I did apply that case in the Rudder hearing when I decided it, and I essentially went against my prior decision because I thought my prior decision was too narrow, and for a civil administrative hearing that my thinking needed to be broader and include all definitions of way, and that the statutes related to DUI and administrative license suspension are intertwined, in that it would not make sense to apply a different way definition to one part of RSA 265A than you would to another part.
Okay. Sergeant, do you have anything that you would like to
Senator, I
add?
think he cleared it all up. It would just be very, very confusing for our police officers and law enforcement out there to have basically enforcing DWI in two different mechanisms on different types of ways. And if we could clarify that for them, the procedural aspect of DWI, it would be far better for us to have it the same exact way every single time.
Okay. Thank you for your testimony. Are there any questions from the committee? Mr. Casco, in just briefly looking through this case, was one of the important elements of this particular case the fact that the police officer observed this individual getting out of their car, going to the trunk, getting a bottle of alcohol, and going back to the car? Was that an important part of the case?
It was important in that, and also the respondent testified that she had not drank before coming to the parking lot. So to me, that was important because I could not admit, there was no evidence that she had been drinking and driving and she would have had to drive onto a way to get into the church parking lot. I thought there was no evidence to support that. Therefore, it's limited to her conduct solely within the church parking lot, although based on actual physical control, because she was behind the wheel with the vehicle running, she was in actual physical control. If she had been in the back seat, then I would not have sustained that suspension. And I have had a hearing since the new definition of actual physical control where the accused was in the back seat, and I dismissed the administrative license suspension. I had remembered the law, that we changed it, and I thought, wow, I get to use the statute that I was involved with when it became law, so that was a very exciting case to be able to use and to decide.
Well, Senator French is very happy because it was his bill.
Thank you,
so
Senator.
he's pleased to see that the law is actually working. So
It is.
congratulations, Senator. So are there any further questions from the committee? Okay, seeing none, thank you very much for your testimony.
Thank you.
Are there any other members of the public that would like to testify on Senate Bill 1333 FN? Okay. Senator Khan?
It's not a testimony, but it's just a question. Is there anybody who can answer the base of this bill? The current law is 10 years. This is going to 20 years. Is there anybody who cares to address the why double it?
Mr. Broadhead, would you like to come forward and answer that question, or Mr. Casco?
Do you know the answer to that? Do you know the answer to why? Thank you, Madam Chair, members of the committee. I don't know the actual answer, but I can tell you what it does with the statutory scheme. The purpose would be to extend the look-back period so that you can have an enhanced penalty for a longer course of conduct. So it would provide, with the law would be less forgiving to repeat offenders.
If I might, the number of repeats over a 20-year period, over a 10-year period, okay, it's been in statute. Is there a problem with that? Because at doubling that to 20 years, that's, a third of my lifetime. It could be a half of somebody's or 2/3 of somebody else's. It's a long look back.
It is, the current standard is 10, but I think the idea is that this applies to second and third times, that, you do have repeat offenders, we've seen them. Yeah, I think I would defer that question specifically to Representative Abbas, who sponsored the bill.
Yeah. It'd be good to have a history of what it is that we're trying to solve. Besides just number of times over one's life.
Mr. Lehman, would you like to weigh in?
7-year look back maybe 5 or 6 years ago, and that was expanded to 10. And the other question I have is just about the specific language of the bill. It says for a third offense, if the complaint alleges that the prior conviction occurred within 20 years preceding, is that the first conviction or the second conviction going into the third?
Which line? Sorry.
I'm looking at as amended by the House version of 1133, right?
Yep.
And right in the very first piece says, the complaint alleges that the prior conviction occurred within 20 years preceding the date of the present offense. Does that mean that the first offense could have happened 29 years ago? The second offense could have happened 9 years after that? And the third offense is 20 years after the second offense? So the first offense is in a 29-year window, or almost a 30-year window, right? I don't know if that's the intent going on.
I don't think it is.
Right.
Okay, well,
So we could fix that.
yeah, we'll take a look at that.
Our office is happy to offer technical amendments. We do have Benjamin Mackey is our traffic safety resource officer. It's especially assigned to, on the topic of DUIs and other traffic related. So I think for sure he would be able to offer some red lines as well, so we can work with you.
We'll be happy to work with you, with your office to clarify that. Senator Gannon has a question.
If you can help me with just 2 little easy questions. Thanks for taking them. First one would be, why are we treating out-of-state convictions differently with the 10-year? It carries over onto the second page, line 30, 28 to the first 3 lines on page 2. Why do we treat that 10-year instead of 20 like we do in-state convictions?
I don't know the answer to that.
And my follow-up to that, thank you for trying to answer that, would be if they have different intoxication levels at different states, say somebody's a 0.5 or 0.6 or 0.08, would that not be would I bring that up as a defense attorney, saying this wouldn't even be a conviction in New Hampshire, so it shouldn't even be here?
It's possible that would be argued. The question of it being reasonably equivalent is a term that is used in the motor vehicle code in other locations. It's also used in the sex offender statutes of the Department of Safety. So there is some, that term reasonably equivalent is basically you compare apples to apples, not apples to oranges. And there is some case law backdrop to that in the nation, if not New Hampshire.
Okay, thank you.
Thank you.
Okay. Are there any further questions? Seeing none, Mr. Casco, I saw your hand come up. Please come forward.
Yes, Senator. Chris Casco again. I watched, the beauty of YouTube and live streaming is that I was able to watch this morning the House hearing on this bill, and I can try to relate what Representative Abbas presented as his intent for the bill. And this, my understanding and my read of it is this would increase the look-back window to 20 years for third offense and for fourth offense only, not for first or second offense. And the intent is to really address those drivers who sometimes show up in the news. They had 10 prior DUIs, but if they're spaced out older than 10 years, they're only being prosecuted for a Class B misdemeanor. So I think the intent is to try to address some of those egregious repeat offenders with starting at third, fourth, and beyond, not to really increase the window for the first offender or even for the second offense, but to really address those problem cases. And Senator Gannon, in terms of using out-of-state offenses. It could only be used if it's reasonably equivalent. One type of prior offense from another state I used to deal with as a prosecutor was in the state of New York, is my memory. There was a driving while ability to drive was impaired, and sometimes we would charge that as a second offense, but then we would get the paperwork from the court in New York, and the determination was, no, this is not a DUI. It's not reasonably equivalent, so we would not use that as a predicate offense for our current case.
Awesome, thank you.
You're welcome.
Okay, are there any additional questions? Okay, seeing none, thank you very much.
Thank you.
Are there any other members of the public that would like to speak to House Bill 1333? Okay, seeing none, we'll close the public hearing.
Right.
Okay. Okay, are you ready? Okay. We're going to go ahead and open the public hearing on House Bill 1577. Representative Abbas is not available, but I will go ahead and open the public hearing. Introduce the bill, and I do have an email from Representative Abbas, which I will read into the record. For the record, my name is Sharon Carson. I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn, and I have for your consideration this afternoon House Bill 1577 FN, relative to exemptions from prosecution for victims of human trafficking. This bill establishes exemptions from prosecution for victims of human trafficking and establishes procedure to protect the privacy of court records related to human trafficking and for vacating convictions and juvenile adjudications in human trafficking cases. The language of the email that I've received, he offers his apologies for not being here today, and he, dealing with this legislation, the majority believes that it is an injustice for victims of human trafficking to have criminal charges or criminal convictions that directly relate to being trafficked. House Bill 1577 prevents this injustice from occurring in the future and gives victims the opportunity to correct this injustice. The language inside House Bill 1577 is similar to the language previously included as part of Senate Bill 122 that previously passed both the House and the Senate. However, Senate Bill 122, 122, failed in advance in the Committee of Conference because Senate Bill 122 was included in an omnibus type bill. As such, the policy provided for in House Bill 1577 has already been supported by both the House and the Senate, and he thanks us for our consideration. Okay, the chair will call Lynn Charlotte.
Good afternoon, Madam Chair. Do I need to hit a button here, or are we on?
Yes, you do.
Okay.
Well, yep.
Leave it.
Leave it. We're good.
Thank you very much. Good afternoon, Madam Chair and members of the committee. My name is Lynn Chalette. I am the Executive Director with the New Hampshire Coalition Against Domestic and Sexual Violence. I'm here today to speak in support of House Bill 1577. New Hampshire's current human trafficking statute has successfully worked to allow victims of human trafficking to vacate certain convictions, as you heard in the sponsor's description. And those are convictions that happen as a direct result of being trafficked, while also maintaining safeguards to ensure that their traffickers can be prosecuted for their crimes. So this bill continues this legacy by striking the right balance between making sure that human trafficking cases can effectively be prosecuted while also recognizing the complex and very nuanced reality that's experienced by human trafficking victims. The bill does this by doing two specific things. One, it includes language to ensure that those convictions are directly related to the trafficking, and it also limits the scope of crimes that can be vacated to non-violent offenses. So this legislation is consistent with the underlying spirit of the existing law, which is to protect trafficking victims from being prosecuted for something that they likely had no choice in doing because their conduct is so closely linked to the trafficking. However, individuals who commit violent crimes should not be given blanket immunity for any criminal conduct committed at any time in their lives. In the human trafficking field, we recognize the intersectionality between victims and offenders and the phenomenon that sex trafficking victims face with related criminal charges. What that means is that we consider the impact of force, fraud, and coercion and that they might have on a human trafficking victim. So this legislation has been widely vetted, including through the statewide Human Trafficking Task Force, which is made up of prosecutors, law enforcement, and victim advocates. So today we would ask that you consider this legislation and we encourage you to vote in favor of it. Thank you very much.
Thank you very much for your testimony, Ms. Chalette. Are there any questions? Seeing none?
Thank you very much.
The chair will call Melissa Bruto. Did I get that correct? Bruto. Thank you.
Good afternoon.
Good afternoon.
Thank you so much. My name is Melissa Bruto. I'm an attorney and advocate for survivors of human trafficking and all people in the sex trade. I am based in New York, but have had the honor of advising legislators and attorneys throughout the country on vacating convictions. I filed and won the first ever motion in the country on vacatur. It was in New York in 2010, as New York had the first ever vacatur law. Since then, I've been able to advise other lawyers in New York and throughout the country, as well as legislators, on how to craft their vacatur legislation and also how to implement vacatur motions in practice. And so I'm here to offer my very strong support of this bill. It would be, as Ms. Chalette had said, a huge step forward for survivors of human trafficking who should not have to live the rest of their lives marred by a criminal record that happened as a direct result of being trafficked. And this will go a long way in allowing survivors to move forward with their lives. And we in New York just expanded our vacatur to allow for all crimes because, as we know, people that are trafficked are forced to commit a wide array of crimes. So I'm in extremely strong support of this bill, and I think it will go a very long way to helping bring very needed relief to survivors of human trafficking in the state of New Hampshire. Thank you.
Thank you very much for your testimony. Are there any questions for Ms. Bruto? Seeing none, thank you.
Thank you.
Hey, are there any other members of the public that would like to speak to House Bill 1577? Okay, seeing none, we'll close the public hearing. Thank you. Are we all set, Jenny? Okay. We're going to go ahead and open the public hearing on House Bill 1206 FN and recognize the prime sponsor, Representative Lynn. Good afternoon, Representative.
Afternoon.
Madam Chair, members of the committee, thank you for permitting me to testify in favor of this bill. This is basically a housekeeping kind of bill. As you may recall, I think it was last year, maybe it was 2 years ago now. At any rate, the legislature passed a bill that sort of expanded the circumstances under which DNA testing could be allowed for defendants claiming innocence. And it provided for the costs of counsel for indigent defendants who were making such a claim, and also for the costs of the testing for people that were indigent. It didn't specifically say where the money was coming from. And so this bill was designed, I introduced it at the request of the judicial branch because they were concerned that there was, that these funds like this should be coming out of the Judicial Council budget, where similar things always have come out of, and they were concerned that it would be, that this would be pulled out of their budget, and I agreed with them. I thought it did make sense to that they should come out of the Judicial Council budget, and so that's the reason for the bill. I think Mr. Head is also here from the Judicial Branch. He may have a little bit more to add, but I'm happy to take any questions if you may have any.
Thank you very much for your testimony, Representative. Are there any questions? Senator Gannon.
Just a quick question. So initially, when the petitioner's in prison and he gets the idea that, there's something wrong with my conviction or whatever, the initial petition would be filed by him without the assistance of counsel, right? He'd have to get to a level to show that there was a reasonable requirement. There'd be a burden on him initially.
Right. That's, unfortunately, I should have brought the underlying legislation. I didn't, but I believe that that's right. I know that was, there was a two-step process like that in the original DNA bill that has been around for quite a while.
Yeah.
I believe that is preserved, but so that you don't get counsel,
Until you meet a requirement.
right initially. But I think that's right. But maybe Mr. Head,
Okay, thank you.
can correct me if I'm wrong on that.
Thank you for being here, and thank you for the testimony. Senator Khan has a question.
If I might, Representative, and yes, you wear multiple hats, you can't avoid it. Is public defense come from the same source of funds?
Yes. In other words, the public defender. Well, the public defender has a contract really for with the Judicial Council, but as you may know, there's been a number of challenges with the Public Defender's Office recently. I mean, they've lost a lot of people, and so it's always been the case, and still is, that if for some reason or other the public defenders can't take a case, then counsel is appointed from some other source, and those are paid from funds through the Judicial Council. And in addition to that, other services, if an expert is required or something like that for an indigent defendant, those are also paid through funds from the Judicial Council.
May I follow?
Follow-up?
So is it RSA 604A that is the authorization for the funding to the Judicial Council for public defense, as well as what this would be drawn from?
Yes, that's the statute that provides that counsel services and also services other than counsel can be paid through the Judicial Council.
So where I want to go in a question to you and maybe to Mr. Head, but in any case to you initially, is it a matter of funding for the Judicial Council that public defense is we're unable to provide public defenders for indigent people? Is it a matter of funding? Is it a matter of staffing? I'm going there because this is adding a funding requirement. I just want to understand, What is it that caused the fiscal note on some of the things that we're hearing today to reflect that because of an increase in caseload, we're unable to provide the public defenders to each of the cases that require it?
So I guess, as I understand it, and I think that, I think I have a pretty good understanding of this, but, I've been out of the judicial branch for over 2 years now, so Mr. Head may have more recent information. But as I understand it, as this committee may know, we have got, and I think we can really be very proud of this, we have had one of the best public defender programs in the country. For many, many years, they just had a very fine reputation, did an excellent job, and recently there's been some problems with that in terms of as I understand it, a number of attorneys leaving as I understand it, for various reasons. One, salary considerations. There's been with COVID and with the sort of uptick in the economy as we kind of came out of COVID, there have been a lot of openings for lawyers. If you pick up the Bar News, you can see there are a lot of advertisements for lawyers, and so I think a number of public defenders left for that reason. And there was also a question of the salaries not being competitive. Or at least that's the argument. I haven't done an analysis of that, but my understanding is that's one of the problems is that there just hasn't been, the salaries haven't been competitive. In fact, I know the fiscal committee that I sit on as an alternate just approved a bunch of money. I'm trying to remember how much. I can't remember off the top of my head, but it was in the millions of additional appropriation for the Judicial Council, which was to be used for the public defender program. So I think, it's a combination of problems, and as I say, Mr. Head may have even more detailed information than I can give.
At least we can go to that source and see what was presented as the evidence to the fiscal committee for that additional appropriation, how far off we are, how many cases are pending because we can't provide counsel.
That is unquestionably a problem. I think another part of the problem is that COVID did cause sort of a backlog, a buildup of cases that couldn't be tried and that kind of thing. So I think it's a combination of factors, but I think one of the factors is unquestionably issues of public defenders leaving for monetary reasons and caseload reasons, other things like that.
So just to follow with the question that causes me to ask that on this bill is, and this bill, because it is drawing from the same source of funds for DNA testing for the same client that relies on a public defender, adds to that total amount that is necessary to sustain the office of public defender.
No, that's true. That's definitely true.
Thank you.
Okay, are there any further questions for Representative Lynn? Seeing none. Thank you very much, Representative.
Thank you.
The chair will call Richard Head. Thank you, thank you, Mr. Head. I don't really want us to get too deep into the weeds on the fiscal aspect of this bill. I think, this is a policy committee, and if this bill should pass, it will go to Senate Finance, where people can go into the weeds on this particular issue. So, please, I'm sorry. The other thing I would just like to announce, I have my phone here in front of us. As you know, our colleague, as Senator Whitley is not here today, she's actually on speakerphone, and I have an arrangement with her that if she has a question, that she can text me the question, and I will ask the question for her. So I'm not playing games on my phone or anything else. So please, Mr. Head.
Thank you, Madam Chairman, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch And I appreciate Justice Lynn's presentation. I won't repeat what he said. He did sponsor this at our request. This is a bill that we requested, and it is, as he said, a housekeeping measure. There's a statute that says essentially if appointment of counsel is done by a judge and there's not a statute that specifically allocates how it's going to be funded, it gets funded out of the judicial branch budget. We don't have a budget for indigent defense because that's done through the Judicial Council, which is an executive branch agency. I did, in response to Senator Khan asking a question during a break earlier, Sarah Blodgett from the Judicial Council is here if there were questions specifically about the fiscal impact, but understanding your point also, she is present in the room today if you did have questions. I do not have any answers to her fiscal note, so I won't speak to that. This bill does have the support of the Judicial Council. We did consult with them prior to it. There's not a lot of these cases, and a lot of these cases are otherwise funded through projects like the Innocence Project. So it's not a high burden issue. It's simply a housekeeping. So if there is a case in which indigent defense counsel are appointed, or is appointed, there's a budget line item for it, and it would be in the Judicial Council, which goes with all the other indigent defense costs. As to Senator Gannon, your question earlier, there is a threshold step in the paragraph 1. Fortunately, you asked enough questions of Justice Lynn, so I was able to look it up. But paragraph 1 has the requirements of what should be in the petition itself. The judge does have a screening role to ensure that the standards are met, and if the standards are met, it is only then that the Indigent Defense Counsel would be ordered. And with that, I'd be happy to answer any questions if the committee has any.
Okay, thank you very much for your testimony, Mr. Head. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you.
Are there any other members of the public that would like to speak on House Bill 1206 FN? Okay. Ms. Blodgett, we've had a couple of questions about the fiscal impact of this from Senator Khan. If you could kind of come forward and just give us a very condensed version. Again, I would just like to remind everyone, we are a policy committee. We are not a fiscal committee. But Senator Khan has some very pointed questions about the fiscal impact. So if you can briefly answer his questions, we would appreciate that.
Yes, good afternoon, Madam Chair and committee members. For the record, I'm Sarah Blodgett with the Judicial Council. And I would like to thank Mr. Head and Representative Lynn for speaking about some of the issues that we've been dealing with and addressing that in my absence. So, hi, Senator, how are you?
Fine. Madam Chair.
Yes, please ask your questions.
Yes, and so my question is, are we doing a sufficient job in providing support for indigent people who need public defense? That don't need to quantify how short we are or how much we fund, but I'm concerned that if we are adding another responsibility to the judicial defense budget, how far are we able to do the job that we think that we're already obligated to do?
Thank you for that question. I think it is an important one. As you heard from Representative Lynn, we are fortunate enough to have a public defender program that has been one of the top in the country for many, many years. Right now, I think that it is a national problem with regard to an indigent defense crisis that we are seeing play out in the courts every day. We have lost a large number of staff attorneys at the public defender office. I know that the prosecutors and the county attorney's office are facing some of the same challenges. In this market, somebody can make much more money. The jobs are generally not as challenging outside of this type of public service work. So we have seen a significant decline in the number of longtime staff attorneys at the public defender since the pandemic began. As was previously mentioned, the backlog at the courts, combined with the difficulty that indigent clients have had getting mental health or substance use treatment during the course of the pandemic, has made these cases much more challenging. So we are struggling with that. And right now there are hundreds of clients in the state of New Hampshire who do not have an attorney appointed to them, even though they are entitled to one. This is a new problem. It really began during the pandemic, but during that period of time, there was a decrease in the number of new charges being brought. Now that the charges are getting back up to pre-pandemic levels, we're in a perfect storm. And we're not able to handle the new cases coming in and deal with the cases that were still lingering. And when we lose an attorney in one office, if that attorney had 75, 85, in some cases 95 cases, those are now spread around the attorneys who are remaining. We did just receive a $2.3 million appropriation from the Fiscal Committee to enhance salaries at the Public Defender Office in an attempt to retain more attorneys. We'll be in front of Governor and Council on that item tomorrow, but it is just one piece of the response to this crisis. And so as Mr. Head testified, this is not a significant number of new cases that would be coming to us, but because of the crisis that we are in right now, it is taking us a long time to find attorneys if the case cannot be handled by the Public Defender Office. So we do have quite a bit of work ahead of us to get back to where we were pre-pandemic.
Yeah, may I follow? Just
One?
one? Just one more.
Okay, one more question. I don't want to get too far away from the subject of this bill.
If I wanted to find a source that said, we have X number of cases, 90 days delayed, 120, 180, 365, is there a source for understanding this backlog?
So in the delay of the cases that are currently open, it would be very time consuming, but we have that information. We can get it from the public defender. I think really the crunch is that cases that did not resolve through plea negotiations are now all ready to go to trial. And we can only do so many jury trials, so many district court trials during a week. So there is just this building wait list of cases, for lack of a better term.
Thank you.
Are there any further questions for Ms. Blodgett? Seeing none, thank you very much.
Thank you so much.
Okay, last call. Are there any other members of the public who would wish to speak on House Bill 1206? Okay, seeing none, we'll close the public hearing. We are about 15 minutes behind. That's not too bad. Okay, thank you. Pardon? Sure, you got questions, we'll get them answered.
That's the only way I find out what's going on, Jay. Thank you very much.
Well, that's what we're here to do, folks, because there might be people out there who are members, who are people that are listening, and they might have had the same questions, so we'll get them answered.
Just leaves
Are you all
me
set?
with nothing to ask, ever.
Okay, are you all set? Okay. Going to go ahead and open the public hearing on House Bill 1239. The prime sponsor is Representative Walsh, and I don't believe Representative is here today, but I do see that a co-sponsor of the bill, Representative Gagne, is here. So we're going to call Representative Gagne to come forward to introduce the bill. Thank you, Representative.
For the record, my name is Larry Gagney. I'm a state representative from Hillsborough 13. I think it's still 13. It's going to change, which encompasses Manchester's Ward 6. I'm here to introduce this bill in regards to habitual offender hearings. I'm going to cut through the mustard real quick because those behind me can really better address the situations here. All I know is I was a postal employee for 21 years, and first-class mail is way cheaper than registered mail, and it takes less time, which is why this was a request from the DMV. And I also know that the Department of Safety supports it, and those who will testify behind me have a greater knowledge of what's going on. The only thing added to the amended version of this bill was the last line, "The default order shall be served in hand," because it would be more of a surety that the person would be served. And that's pretty much all I have. Senator.
Thank you, Representative. Are there any
Questions?
Senator Gannon has a question.
Thank you, Senator Carson. So we'll cut to the chase. So you're mailing a letter.
Correct.
Right? And I have 30 days. So in the future, hopefully not too far future, I'll be going down to, like 3 or 4 years, going down to Naples all the time for a month. I'm not gonna get that letter. So wouldn't it be service better to certify the letter? You said wouldn't there be a better way?
It's probably sent certified, but first class rather than registered mail. Registered mail at times takes six days and more, plus the expense. And that would be the big deal with the savings involved will be in the thousands of dollars per year for the state. It'll be sent the same way that it has been now to the last known address of the individual. And they will have 30 days to respond to that. And if they don't, then there'll be a process where the individual will be served in hand if they can find him or her.
Okay, thank you.
You're welcome.
Are there any further questions for Representative Gagney? Okay, seeing none, thank you,
Thank
Representative.
you, Senator Carson.
The chair will call Chris Casco.
Thank you, Madam Chair. Members of the committee, my name is Chris Casco, C-A-S-K-O. I'm the Administrator of the Bureau of Hearings and Prosecution for the Department of Safety, appearing before you here today in support of House Bill 1239. And our office does all of these habitual offender hearings, and we requested this bill to try to simplify the process that we use to certify someone as an habitual offender. Very briefly, a person is qualified as an habitual offender based on the number and type of motor vehicle convictions within a 5-year period. They're some of the more serious law violators in the state of New Hampshire. Many of them present the highest public safety risk of any drivers. So the intent of the habitual offender law is to suspend the licenses of habitual offenders. And unless the committee has specific questions, I won't get too much into the detail of who's a habitual offender and the types of convictions, but they're the more serious violators. But under our administrative rules, the procedure for these hearings is different than other types of hearings to protect individual rights, because most driving in violation of an habitual offender order is a felony level offense. It all used to be felony level, but over time, there now is a misdemeanor level habitual offender. It's not all punishable by mandatory minimum terms of incarceration, but at one time it was. Therefore, our administrative rules to start the habitual offender hearing process required in-hand service of the hearing notice in the driving record and the related paperwork from a state trooper to the person before we could commence the hearing process. So we would be able to track if someone was stopped violating the order, there'd be a clear trail that we serve them a notice for a hearing. If they didn't come in, they would be defaulted and be an habitual offender, but we would be able to document that they were served the hearing notice in hand. Over time, that really has added some problems for initiating the process. It's caused delays for certain numbers of habitual offender candidates, because what would happen, a trooper would make multiple attempts. They would try 3 times to serve someone with their notice. If they weren't able to serve the person, they would go into this unable to serve status. Most of these drivers are already suspended for other reasons, so until they went to try to get their driver's license, they'd just be unable to serve. Some people would go many, many, many years. It would be 10 years. They go to get their license. Sorry, you need to be served habitual offender. We would then do the hearing at that point, and then at that point, the person's been under suspension for 10 years, and then we have the hearing, which should have been done 10 years ago, but because we couldn't find them and serve that person, we never initiated the hearing process. So we're not removing these dangerous drivers from the roadways as quickly as we could, because our rules have this in-hand service requirement. So what we're trying to do with this bill is to allow us to send the notice by regular mail. Our theory is that all drivers are required to update their addresses with a valid current address with the Department of Motor Vehicles. Therefore, we would like to initiate the habitual offender hearings more quickly by mail. Over time, we've studied this issue of the habitual offender process and the need to serve, and how we could better simplify and expedite the process. And one thing we implemented was, at first, we would just send all our paperwork to a trooper. They would try to find the person. The ones they found would come to the hearing. The ones they didn't wouldn't appear. If they weren't served, we couldn't even default them. So we'd have this backlog of habitual offender cases that we couldn't do anything with. This bill attempts to address that, because every week we have people, they'll go to the DMV trying to get their license. It's determined they're unable to serve. Then we're commencing what should have been done a long time ago now. And a lot of times it's to the person's detriment. Maybe they're serving extra suspension time because they couldn't be found by a trooper. So when we studied this, we changed the process to our first step now is we send a letter to everyone who qualifies as habitual offender. Every Tuesday, we have a trooper come to our office at hearings, and the people that come in are served that day. They can have their hearing that day. We've been doing that for quite a number of years now. We have about a 50% success rate of just, and really it's a voluntary appearance by us sending a letter. There's nothing to compel someone to come in and get served voluntarily, but it expedites the process for that person. It saves us from having to send a trooper out to find the person at their home or their place of business, which really could be embarrassing for someone to have a state trooper knocking on the door when their issue really is driving offenses. They otherwise may be a very law-abiding citizen, and all their neighbors see the trooper knocking on the door. So this bill will eliminate that, but we did, as this went through, we initially requested that we be able to do everything by mail. Merrimack County Attorney Paul Halverson, I talked with him. He presented some concerns from the prosecution end with not serving anyone. So I suggested an amendment that for people that are defaulted, we would serve the default orders on people that did not respond to the hearing notice and come in for the hearing. So we feel that was a reasonable compromise, so that we'll try to find people with the default notice, even though they will be certified 30 days after that original hearing date. And certainly if we get return mail on someone, we're not going to default them. We're going to take care to send out these hearing notices by mail to a proper invalid address, and not to just, well, we'll just pick whatever address, and if it's return mail, it doesn't matter, we'll still certify in default and then try to find them. Really, we will be very careful, but in our work of process improvement, this will help us along the way to try to improve this process. I'm happy to answer any questions.
Thank you very much for your testimony, Mr. Casco. Are there any questions from the committee? Senator French.
Thanks, Madam Chair. Thanks, Mr. Casco.
You're welcome.
If an individual has not driven for 10 years and was not served, when they come in to get their license after a self-imposed of not driving for 10 years, are they not allowed to get their license at this point?
We have to deal with the habitual offender. Under the law, the order either, it's a minimum of a 1-year suspension up to 4 years, but there are 2 ways the hearings examiner can run the suspension. For someone who's been under suspension the entire time, it can be run from the date of the most recent conviction that is causing the habitual offender. So for someone who's not driven and has been under suspension for a long time, I can tell you in most of those cases, I'll backdate, for lack of a better term, and essentially they're getting credit for the time served and they can be decertified. Sometimes in an old case like that, we can do the certification hearing and the decertification hearing at the same time and try to resolve everything.
Okay, and the reason I ask, thank you, Madam Chair, is I have a constituent who hasn't driven for 10 years and she's afraid to come in. She could come in and see you at this point?
Yes, absolutely. There are some things, if they have fines to pay and other types of things, that may prevent the hearing, but what we do is send a letter and correspond and say, these are list out, these are the things you need to clear up, please clear them up. Then we'll schedule you for the hearing. The only other piece of it, if someone has unserved implied consent that hasn't run, that can sometimes lead to suspension periods later, although there is, for kind of the 10-year window, if someone has less than 2 DUI or less than 3 lifetime DUIs and hasn't driven in 10 years, they can have a hearing to have some implied consent time run concurrently with other license suspension, but that's the only other area that sometimes complicates things for people are these implied consent suspensions.
Great, thank you.
You're welcome, Senator French. Thank you.
Thank you. I have a question. I've received a question from Senator Whitley. She asks, should the return mail process be somewhere in the bill, meaning the process for when the certified mail doesn't work?
Yeah, I'm not, because we're asking to do regular first-class mail, although if there was a thought that there should be certified mail, then, yeah, I think we would certainly track, like we do with the service in hand, there's documents that track it. So if this paperwork were sent by registered mail, we would track it closely, or if it was certified mail with a return receipt, we'd want to match up the return receipt and put that in the file so we can document exactly where the hearing notice went and what we got back.
If you have an existing policy concerning return mail, do you think that it should be stated in the bill? Just to make it very clear that there is a policy for return receipt?
Yeah, I'm not sure. We certainly would be willing to entertain that. But generally with the return mail, that's noted on the system. And if we get a return mail, meaning the person didn't get the notice got sent back to us, we don't take action until we can locate a good address for that person. And what our staff does when they get a return mail of a hearing notice, they try to search the system to see if there's some alternative address. If the person then emails, we try to get a valid address from them to then get them into the process to be served with the paperwork. Or if it's a non-habitual offender hearing type, we can mail it, or email. We try to use email a lot now as well because then it's immediate. We have a trail. We save it on the system that we sent the person a notice by email and what email address it went to.
I think that what we're really talking about, if you decide to use certified mail asking for a return receipt, shouldn't that policy, your policy on dealing with return receipt mail, be included in the bill if you choose to use certified mail?
It could be, although our preference would be regular U.S. mail and not certified mail.
So I'm just questioning if you do decide to use certified mail, because I imagine there would be a point when you do use certified mail for specific cases, shouldn't the return receipt policy also be included?
I think so, yes. If we were having rules for how we would handle the certified mail, if that were a requirement, would make sense. Or that could go into rulemaking as well, I suppose. Because right now, the in-hand service is not in statute, it's in our administrative rules. But we felt it most prudent if we were going to change that because it's such an important change that we should go through legislation rather than just simply trying to change the rule.
Okay. Okay. Thank you very much.
Thank
Are there
you,
any
Senator
further
Carson.
questions? Seeing none, thank you.
Thank you.
Okay, are there any other members of the public that would like to speak to House Bill 1239 FN? Okay, seeing none, we'll close the public hearing. Yes. I'm sorry? I can reach out to them. I mean, if it's in administrative rules, then I think it's covered. But I just wanted to make sure that there was something there. Okay. Let me know when you're ready, Jen. I think yeah. I'm going to go ahead and open the public hearing on House Bill 411. Is Representative Foster here? Okay, I don't see Representative Foster. I will go ahead and introduce the bill for the committee. For the record, my name is Sharon Carson. I have the pleasure of representing Senate District 14, comprising the towns of Londonderry, Hudson, and Auburn. And I am presenting to Senate Judiciary today House Bill 411 FN, which requires the Attorney General to request information from federal agencies operating in New Hampshire and to compile and display such information on a website. We have one individual who is signed up to speak, and that is Attorney Jeff Streslin from the New Hampshire AG's office. Good afternoon, Attorney.
Good afternoon. Hi, my name is Jeff Strelzin. I'm an Associate Attorney General at the New Hampshire Attorney General's office. Our office is not taking a position on this bill. We simply wanted you to know that although it's unclear exactly how much, this bill will end up costing our office some additional expenses as far as personnel and likely information technology costs. I apologize, I can't be more clear as to how much exactly that will be on both those fronts. It's hard to tell from the bill exactly how much we'll have to do, because that'll depend on whether or not we get any voluntary compliance from the federal government and how extensive that is. But at least on a basic level, we will have to expend some personnel costs, some IT costs for a website, maintaining it, and then again, depending on what the federal government decides to do, it could be more extensive than that because we'll have to provide links as well. So just ask that you take that into account as you consider this bill. Again, I apologize, I can't be more specific on the cost, but it's just not something we can determine at this time. I'm happy to answer any questions if you have any.
Hey, thank you very much for your testimony. Senator Khan has a question.
And thank you, Madam Chair, and thank you, Mr. Streslin, for being present today. I guess I don't know how many federal agencies, how many notices you receive currently, what you anticipate would occur in the future. What is obvious to a novice who asks that question is the follow-up, which is that's a lot of reporting every 5th day of a month. And so I acknowledge that you're probably right. There is some labor-intensive component to this.
Yeah, I mean, it's impossible for us to tell exactly how much we're going to have to do because we can't mandate the federal government to comply with this. This will be voluntary on their part. So it could range from not a lot to, a little bit more than that. The other issue with the bill is it talks about law enforcement officers that the federal government employs. I'm not sure how broad that actually is. Mm-hmm. Would that include, for instance, the NRC, OSHA, in addition to the obvious ones like the DEA, FBI, and ICE? So that's why it's hard for us to determine exactly what this is going to look like, unfortunately, less than until the bill passes, and then we see what kind of voluntary compliance we get with the federal government. So again, it could range from minimal to greater
And it's just hard to tell at this point because we've never had to do this before and don't know what we're up against.
Okay, thank you. Senator Khan has another question. And then, I know you're anticipating a question, but
Don't forget it.
we'll let Senator Khan.
He's
Go
probably
ahead.
going to ask my question. Go ahead.
Okay, well,
I
we'll
don't-
see what
I-
happens.
Go ahead, Senator.
Is this a problem that's known to the Attorney General's office?
Well, I guess a problem of what? I mean, I'm not-
Of federal agencies, employment enforcement without the awareness of the Attorney General?
So when we engage in law enforcement operations, there's a term called deconflicting, which means that we try to ensure that another agency isn't involved. So for instance, if we're going to go out and do some kind of drug interdiction activity, we would check with our federal counterparts to make sure that they don't have undercover officers involved in there. So we do those types of things with each other to try to avoid problems. And that's how we would typically learn that they might have an ongoing operation that could cross over to something that we're doing. Both federal and state agencies, especially in a small state like New Hampshire, I think we work extremely well together. There's a high level of cooperation, not a lot of turf fights. And obviously mistakes can happen, but I will tell you that both sides take significant efforts to try to make sure that there aren't problems between the two. So that's how we typically run into it is we're going to conduct something, they're going to conduct something, we check with each other. But certainly there are also just, we may have, a particular death case and we may talk with our, about resources and things like that. So it's a conversation, so I can't say that there's a problem between our agencies as far as operating together.
Thank you.
You're welcome.
Senator French, did your
Thank you.
question get asked?
Kind of, but
Okay.
I'll rephrase it a little bit. Thank you. Can you tell me, dealing with the feds then, how much of this information do you think they'd be wanting to give you monthly?
I would say probably none.
That's what I thought, okay.
But I don't want to speak for them.
You're right.
I mean, they operate with different standards, and sometimes they're more forthcoming in areas than we might be, and vice versa. But it's voluntary on their part. I'm not sure that they would necessarily want to take on the additional work either. So that's why it's hard for me to tell you what this is really going to entail for us as far as extra effort.
So,
Follow-up?
thank you. So in order to comply with this law, your agency would have to find someone in each agency that would be willing, that would be your contact person to get this information from, correct?
I think it would start with determining what exactly these terms mean about what are the types of agencies we have to contact. So I think that would start with there. What are the parameters? Who do we actually have to contact? Find a contact in there high enough who can entertain this, and it may we start with one person and works its way up. We send them this list and find out whether or not they're going to comply or not, and if they are, to what extent.
Okay, thank you.
You're welcome.
Thank you, Attorney Streseland. My concerns really are on lines 9 through 12, where they talk about federal agents and military personnel traveling through the state. We have, of course, we have our own National Guard, and oftentimes they do periods of active duty. They will go on active duty, and they would be classified then as being a federal, a federal military personnel. You also have our Army Reserve as well as our National Guards doing their 2 weeks of annual training where they're actually on active duty. So I have some concerns that this is not spelled out very well in this particular section.
They're exempt.
Yeah, there's actually, the last line says, shall be exempt from paragraph 1, Senator. So as I read that, I believe it would exempt them.
Okay, all right.
I believe
see.
so, and again, I just want to have a
Yeah,
caveat
no,
that
I saw that
it's new,
because-
and that's how I would read it. And maybe the sponsor could address what their intent is as well, and that would be helpful.
Yeah, unfortunately, the sponsor isn't here, so
I don't blame them.
we're kind of flying blind here.
But I appreciate your concern, because when we first read that first part of the paragraph, we thought, how are we going to do that? And then
Right.
it said at the end, shall be exempt.
Well,
So-
I was also concerned that there might be some issues concerning Homeland Security. with this as well.
Correct.
And so I just, well, unfortunately, we don't have anybody here to explain to us why, and quite frankly, and explain to us on record why this bill is needed. So it's concerning to me. So are there any further questions from the committee? Okay, seeing none, thank you very much.
Thank you for your questions.
Are there any other members of the public who wish to speak to House Bill 411? Okay, seeing none, we're going to close the public hearing. Thank you all for being here this afternoon. We really appreciate it, and we are done for the day. Thank you very much.
Nice.
I did, but I